Okay, so Paul Townsend, what are your thoughts about the introduction of all of this Morris Black trial? It is literally a trial within a trial.
So now we're having a trial next to a trial within a trial because we've been discussing, Susan Berman, but in the context of Kathy Durst and now Morris Black. And I have a real issue with how much of the Morris Black testimony is coming in, considering the motive for the Susan Berman murder was supposed to be the issue that she was going to rat him out with regards to what happened with Kathy Durst. But Black was killed the year after Berman was killed. So there's no way that anything relating to Black could have impacted Durst's potential decision to kill Susan Berman if, in fact, he did so. So everything that's coming in regarding Morris Black is so far removed from anything related to the Susan Berman incident that I can't believe that this judge is letting them put on a full-scale retrial of the Morris Black incident for which he's already been acquitted of the murder.
Yeah, Paul, let me just follow up with you on that because that's pretty much the sentiment that myself and Mike have. And we don't know the pretrial motions. We don't know the rulings. I know the prosecutor's like, we argued this and the judge ruled this way. Well, judge ruled a certain way in Bill Cosby too, and many of us were speaking about as prosecutors, as former prosecutors, that wow, they're introducing things and doing things like the deposition testimony after he waived his didn't have the Fifth Amendment rights and then used it against him, and it's what we all know that is odd, and it goes back to that point that we say as prosecutors, just because you can doesn't mean you should. To your point, it's so attenuated, and I think maybe our audience may and the public in general may not understand what we're saying exactly, but the rule that we're talking about is bad act evidence, and bad act evidence is generally disfavored. It's not supposed to come in unless you can narrowly get it into for certain categories: motive, opportunity, absence of mistake, common plan or scheme, so on and so forth. And then the case law limits it so that the prejudicial value doesn't outweigh that probative effect. And the courts look at that and they're very cautious about how much prejudice occurred. And to your point, even if when you say it goes to motive, it's something that's occurring after the fact. When you add the Kathy Durst stuff, when you add the Morris Black stuff, let me add to it, you can also get to that point about Morris Black if that's what the judge allows and that's what you think you can get away with in your appellate courts. But now showing the jury body parts, how is that at all relevant? And we also know courts, I'm sorry to go on, are very wearisome, even in a real murder case, of that person showing too many photos that could really, unless it goes specifically to the homicide itself. Here we're showing for a homicide he's acquitted of.
Yeah, everything about this is outrageous, I think is the right word. I've been in a number of trials where a lot of back and forth was spent determining how many photographs and these pictures are too graphic and you only need these, and the judge has put limits on the amount of graphic material that can be shown to a jury. And the idea that extremely graphic images of a murder accusation that he was acquitted of that is not related at all to the crime that he's on trial for is simply staggering. The amount of evidence that this judge, and I use the term evidence lightly, but the amount of information that this judge has allowed into this trial that really has no bearing on the guilt or innocence of whether or not Durst murdered Susan Berman is really concerning from an attorney standpoint, not just a defense attorney. Because if I was John Lewin, I would start being concerned that all of these issues are going to build up into a very, very strong appellate brief. And the last thing he wants is this case to get overturned. The last thing Wyndham should want is this case to get overturned. So I think there's a lot of problems with what the prosecutors are putting in. And I think there's a lot of problems with what the judge is allowing the prosecutors to put in.
Yeah, and Paul, real quick, there's a reason for that rule that limits bad character evidence from coming in and only narrowly circumscribes it. It's because it has been found that sometimes jurors are more poisoned by that than the actual facts of the case. 15 seconds or less. Do you agree with that?
Absolutely. The idea in a criminal trial is we put people on trial for the actual thing that they're accused of, not things that they've done in the past. And if we use things that they've done in the past, we run the risk that the jury is going to convict them because they're going to say, well, he did it 10 times before. He definitely did it this time, even if the evidence isn't there.
Gentlemen, I'm going to tell you something that's amazed me. The politics and then the court of public opinion, if you're on this side, all the rules can be thrown out the door so long as you get the conviction. And if you're on the other side, all the rules should apply so that the person doesn't get convicted. It seems to me that people are basically doing this based on whether they like you or don't like you as a defendant. And that's how the evidence rules are supposed to move. Unfortunately, that's not how the courts see it. But nevertheless, that's what I'm saying. Guys, great commentary. Great having you here. You two guys are both pros, know these evidence rules inside and out. We're going to take a quick break here on the Law and Crime Network. We'll be right back.